Hello there. This is An Architect Goes to Law School. Today in civil procedure class, we'll talk about the certificate of merit requirement that some states have when a party wishes to sue an architect. A handful of states have enacted statutes that directly affect much of the litigation involving architects. At their core, these statutes share the common element of requiring an entity initiating a lawsuit against licensed professionals, such as architects, to provide a sworn document that states the design professional has committed errors in their professional work. This can be included with the petition or must be provided very soon afterward. This sworn document is called a certificate of merit in some states and an affidavit of merit in others. The current list of states that have these certificate of merit requirement statutes consists of Arizona, California, Colorado, Georgia, Maryland, Minnesota, Nevada, New Jersey, Oregon, Pennsylvania, South Carolina, and Texas. Other states have taken a different route by requiring an entity that wants to sue an architect to initiate and prosecute their claim in front of an independent panel of similar professionals. These states' implementations of this alternative dispute resolution is separate from both the public court system and the private arbitration system because they are statutory in nature, but must be followed just like other statutory requirements for lawsuits. Currently, the states of Hawaii and Kansas have these professional claim panel statutes. The reasons legislatures have enacted these statutes include preventing non-meritorious lawsuits and arbitration proceedings from wasting potential defendant architects' time and money. As with many other pieces of legislation, it should be noted that some defense attorneys have successfully used these statutes to get meritorious lawsuits dismissed on procedural grounds. While the various state certificate of merit statutes share some important similarities, there are also some impactful differences. One such difference is who does the certificate drafting and signing. That is, which participant in the litigation process attests to the potential defendant's professional misconduct under penalty of perjury. Some states require third-party architects to draft the sworn statement, while other states require that the plaintiff's attorney draft and sign the attestation. In many of the states where the attorney drafts and attests to the certificate, what they are really swearing to is that they have consulted with a third-party architect who says the potential defendant architect did engage in professional misconduct. A review of the various state statutes shows that third-party architects' professional opinions are critical to the certificate process in most, if not all, of the litigation and design claim panel processes. Another difference is who evaluates the certificate of merit. In most states, the certificate is part of the judicial process and is evaluated by the presiding judge. The judge in such a case will evaluate the certificate for its adherence to the statutory requirements and will hear and rule on arguments made by any party opposing the certificate's inclusion in the legal proceedings. Hawaii, however, has a design claim conciliation panel which reviews the certificates. Hawaii's panel consists of at least one architect and one attorney. Following the panel's review of the evidence, potential plaintiffs may commence litigation against a potential defendant architect. In Kansas, a professional malpractice screening panel engages in similar actions. Kansas requires 3 licensed architects to participate in the assessment of the alleged professional malpractice. The Kansas panel is also optional, based on a potential defendant's written request. Therefore, it may be a best practice for a potential defendant architect to request that the Kansas panel be convened. This is because their alleged actions would be evaluated by the panel's architects, who are hopefully more familiar with an architect's standard of care than a judge is. Importantly, a Kansas panel's written findings are explicitly admissible in subsequent court proceedings. A third difference is whether the statute specifically controls arbitration proceedings. Some states have said yes to this, and some haven't decided yet. Texas's statute specifically says, quote, in any action or arbitration proceeding for damages arising out of the provision of professional services by a licensed or registered professional, end quote. Hawaii's Design Claim Conciliation Panel statute also explicitly mentions arbitration proceedings. Further distinguishing the Texas Certificate of Merit judicial interpretations, Texas courts have held that its Civil Practices and Remedies Code, Chapter 150 Certificate of Merit requirement doesn't apply to suits that only concern payment for the professional services. If a suit is about the quality of work, a plaintiff must have a certificate of merit from a licensed third-party architect. In Texas, at least, there are court cases that have held that if the suit is about the money owed, not possible professional malpractice, then no certificate of merit is required to be drafted, signed, and filed along with the lawsuit. Feel free to comment, ask questions, and suggest topics you'd like me to discuss. Next up, we'll start a series of videos about the phases of a lawsuit. Thank you for watching An Architect Goes to Law School.